My name's Ken Carlson. I'm an attorney specializing in renters' rights since 1980. I'm a graduate of UC Berkeley and Loyola Law School, and I provide the caltenantlaw.com website. This is an introductory free consultation on your rights as a tenant. Whatever it is that you're trying to find out is explained in other free consultations of this group on the Cal Tenant Law website or by a paid consultation with one of my attorneys arranged through that website. You first need to understand that landlord-tenant law is a special area where the normal rules do not apply. As you may be aware, during the COVID crisis, there were many special laws enacted for tenant protections, and there are other special laws throughout the state of California and in the local cities and counties. Therefore, what your actual rights are will depend on the city you live and the circumstances of your situation as they match the laws that are available. One size does not fit all. As much as we can tell you are the general laws that apply, so that you have an idea about what more you need to know. Secondly, there's a lot of misinformation floating about and a large number of quack paralegal firms that promise the world to you but leave you worse than you were after charging you more than a lawyer would for the same services. A paralegal is anyone who says they are. A paralegal has no license and therefore no license to lose. The landlords don't demand that these quack firms be driven out of businesses for practicing law without a license, because the landlords would prefer that you go to one of these paralegal firms rather than find out what your rights are through a competent lawyer. These paralegal firms may even be sponsored by landlords to mislead you, thinking you are getting good advice. Don't waste your money. The court clerks are just as bad. They think they know what they're talking about because they've been misleading the tenants for years and no one corrects them. They are often biased against tenants and intentionally give you a hard time or mislead you. Third, in landlord-tenant conflicts, time and details are very important. You have 3-day deadlines, 5-day deadlines, 24-hour deadlines, and strategic deadlines that you have to meet or you'll lose the case. Things have to be done correctly or they have no effect at all. You have rights, but if you don't do things correctly, you give up those rights. That's why it's so important to get correct legal advice. Landlord-tenant law is a narrow specialty, and only a few lawyers help tenants. Going to a prepaid legal service that you might have is a waste of time, because they only have a little knowledge about this special area of law. Whether you use caltenantlaw.com or one of the other law firms that we list for you on our site, you really need to talk to a lawyer who specializes in helping tenants, period. Finally, it's best that you stay ahead of the game at all times, anticipating what the landlord may do and taking action to block that strategy. Things that you do or don't do in the beginning can make a big difference in the final result. To wait and see is the most dangerous strategy for them. Always be proactive, stay informed, and follow the attorney's instructions. Evictions are the most common situation facing tenants searching for information online. With the economy still in shambles after COVID and many of the protections created during that period being out of effect, landlords are eager to evict whenever they can, thinking that they can fill the vacancy with someone paying even more. They may just want to sell the property and get you out any way they can. The judges that are assigned to handle eviction cases are usually strongly biased against the tenants at a level of corruption never seen before. Getting away from the crooked judges, maneuvering around the sneaky tactics used by the landlord's lawyers, and asserting your rights in a way to achieve what you want have become even more important than your rights. If you get cut off or can't get in front of a fair judge who will follow the law and not just be a point man for the landlords, your rights don't even matter. I wish that were not true, but I have a duty to you in our landlord-tenant relationship here to tell you the truth. Evictions, with rare exceptions, have to go through court. The landlord cannot simply change the locks, turn off the utilities, throw your stuff outside, although they threaten to do so. You can call the police if they do. The eviction case in court is called an unlawful detainer. Usually, the process begins with a notice, like a 3-day notice to pay rent or quit, or a notice of termination of tenancy. After that notice expires, the landlord files the unlawful detainer action, and you have to be served correctly with the summons and complaint. Where your case goes from there depends on what you do, how the judge rules, what tactics the landlord's lawyer uses, and several other things. The caltenantlaw.com website has a special section on evictions and a flow chart called the Unlawful Detainer Game Board, which can guide you on how things go. The landlord thinks he can have you out in a few weeks, but if you do things right, you could stay in possession for several months, even years. My record is 5.5 years, with a few in the 4-year range and many in the 2 to 3 year range. Every case is different. Evictions are divided into 2 kinds. 1, where you are accused of doing something wrong, and 2, when the landlord just wants you out. The first category includes non-payment of rent, violating some other part of the rental agreement, creating a nuisance, subleasing, or permanently damaging the property. For each one of these, there are defenses you can raise to win the case by showing that the landlord's accusation is incorrect and or that other circumstances make the eviction illegal. There are other videos in this series that explain these different types of eviction defenses and how to win. The second type is may just involve the expiration of your lease, or that the landlord wants you out in order to move in, remodel, demolish, or sell the property. It also includes where your landlord lost the property in a foreclosure, and the bank or whoever bought the property at the foreclosure sale wants you out to flip the property, a term meaning making minor improvements and then selling it at a high profit. Again, for each one of these, there are defenses that you can raise either to show that the claimed reason for eviction is incorrect, that the eviction is illegal as a retaliation, or that special law or procedure were not followed. There are other videos in this series that address these evictions as well, so you can understand that you can win these cases too. Even though evictions can be a nasty, brutal, and intimidating experience to begin with, once you get into it and see the game board process proceed as planned, you learn that just doing it right can get you the time and leverage you need to accomplish your goal. When you handle things as we direct you, what you'll find is that by the first day of trial, the bully landlord is finally afraid of what you're going to pull at trial that his expensive lawyer is not ready for. 90% of our cases settle on that day with terms acceptable to you, if not a glorious victory that several of our tenants have enjoyed. It's the tight housing market over the past half-century that has gotten landlords to neglect their duty to provide you with a habitable home. They say, if you don't like it, move, or they try to evict you for even complaining about it. They have the legal duty, under the special relationship of landlord-tenant, to tell you about the defects before you move in, and, under the implied warranty of habitability, they have the duty to fix anything that affects your living there, from broken heaters to cockroach infestations. They commit fraud and breach the contract by not doing these things. But what are you going to do about it? You have the right to repair and deduct under Civil Code 1942, spending up to 1 month's rent, 2 months in a row, to fix things that the landlord won't fix, and deducting that cost from your next rent check. You can call the City Building Department Code Enforcement Division and have the inspectors cite the landlord to make him fix things. You can call the County Health Department's Vector Control Division for cockroaches, mold, rats, and other living things, and their Environmental Services Division for things like asbestos and other unsafe conditions. You can call the local fire department, non-emergency line, about fire hazards like sparking electrical outlets, overloaded breaker boxes, and other fire hazards. Those are government agencies whose service costs you nothing, and whom the landlord has to obey, or he goes to jail. You can withhold rent if a major defect or combination of defects collectively substantially reduce the value of the rental under the implied warranty of habitability. You can sue the landlord in small claims court or in a regular superior court case for his breach of contract and nuisance that these things cause. Or, under Civil Code 1942, you can just move out without further notice and owe nothing after the day you leave, if you prefer. You can do all of these things or just some of them, as you wish. You can download the habitability worksheet from the caltenantlaw.com website to help you identify all the types of things that you have the legal right to fix. You want to make sure that you do these things correctly and are taking proper precautions against the landlord's retaliation. So some legal advice for your particular situation would be very helpful to make sure you're doing it correctly. As the tenant, you own the right to possession, and the landlord does not. When the landlord rents you the place, he sells you on a temporary basis the exclusive right to possession. That's what renting is. Otherwise, it's like the sidewalk. The landlord would rather have the money than the right to possession, so he made the choice. Having sold you the right to possession, the landlord cannot simply walk in any time he wants because he holds title to the property. Oh, he still has title to the property, the right to borrow money against the property in a mortgage, the right to deduct costs of operating your rental from his taxes, and the right to regain possession after you leave. Even if the landlord is evicting you, he does not have the right to possession until after the sheriff has removed you. Now, the landlord can come in under a special law, Civil Code Section 1954, which limits the reasons to 1. An emergency, like a fire, 2. Your permission, 3. To make repairs, 4. To show the property, and 5. To do the security deposit preliminary inspection 2 weeks before you leave. That's it. Only those 5. They can only come in during normal business hours, after a 24-hour notice, and they cannot abuse that right. If the landlord or his agents try to come in, you call the police. The cop's watch commander can tell him about it if the officer on the scene doesn't get it. He is to keep the peace, tell the landlord it's a civil matter, and tell the landlord to go away. Even the cop can't come in without a warrant, so he stays outside too. You are in control here. The landlord or his agents cannot come in just to snoop around, take pictures, go through your closets and drawers, or even talk with you unless you permit it. The landlord cannot hold an open house for real estate sales purposes, or require you to leave for that or extended construction he plans, because that would be an abuse of the right of entry. He cannot have a lockbox with a key to your home hanging outside to let any realtor enter using that key without your permission. He cannot have excessive showings of your home because that is an abuse, although only for real estate purposes the normal business hours limit includes weekends. Of course, you can bargain with the landlord, such as waiving the rent during the real estate showing months, paying your full costs for your hotel relocation, meals, and incidental expenses if you have to be relocated, and to pay you a nice money bonus for having cooperated. There's a lot more to this, and you probably need some specific legal advice to make sure you're doing it correctly and under your circumstances, and protecting yourself from the landlord's retaliation. You can find out more details on trespass in the related video on that topic. For now, you understand that you are in possession and you control things, not the landlord. A security deposit is your money that the landlord holds in trust to apply only to unpaid rent, damage that you cause, necessary cleaning, and any missing items that you took with you. It can be up to 2 months' worth of rent for an unfurnished place and 3 months' worth for a full furnished place. It can be raised when the rent is raised, but only within those limits. And it must be refunded to you, or any deductions from it fully accounted for, within 21 days after you leave. If the landlord withholds your deposit in bad faith, you can get up to triple the amount of your deposit in a lawsuit against the landlord. The landlord cannot use the deposit to repair nail holes, scuff marks, and other normal usage. Painting is not a legitimate deduction because it's neither repair nor cleaning. Things that you did not damage are not deductible from your deposit. If you left the place as clean as you got it, the landlord cannot charge you for cleaning. It's best that you hire a cleaning company to shampoo the carpet and clean the place before you leave, and take pictures of how you left it. So you have the receipt and the pictures to show the judge in case the landlord claims that you trashed the place. You can watch the related video on security deposits to get more detail and the strategies to use. If you're evicted, the landlord does not own your personal property, you do. The landlord is required to let you get your things back and cannot impose unreasonable time slots to do so. The landlord has to store your personal property in the place you lived at the daily rental rate, or move it to a storage locker and release it to you upon your payment of the costs of moving and storage. The landlord cannot simply throw your personal property away or move it outside for the public to pick over. You give the landlord notice that you want it, and the landlord gives you notice of your right to get it, both providing 15 days within which to act. After that time, the landlord has to publish an auction notice for a month and then sell it. Only if the landlord reasonably believes the total value of everything is less than $700 can the landlord throw it out after the 15-day period if you show no interest in claiming it. If the landlord does anything else, you can sue for the value of the property, statutory penalties, punitive damages, and even your attorney fees. Although most rental agreements include a late fees provision, that part of the agreement is void and unenforceable, like agreeing to work for less than minimum wage. If you've paid them to avoid an eviction in the past, those amounts you paid carry over against current rent, so that if you owe $3,000 in rent but paid a $50 late fee 10 years ago, you win the eviction, because you don't owe $3,000, you only owe $29.50. If you get a new rental agreement that includes that late fee provision, don't spill the beans. Keep this as our little secret until later when he tries to evict you for non-payment. Late fees, like bounced check fees, are called liquidated damages provisions, meaning an arbitrary amount like $100 for breach of a particular part of the lease, like not paying by the 5th of the month. They are illegal under Civil Code 1671 because the landlord's loss from just paying late is easy to calculate. It's about 136,500th of the month's rent per day. That's 1% per year interest on the checking account, and 1/365th of that per day, about a nickel or dime, not $100. Since that's easy to calculate, under Civil Code 1671, it's illegal to charge. A late fee also has to be the result of a reasonable endeavor to calculate the actual losses from non-payment of rent, and be the average of those test results. Late fees given in the rental agreement have nothing to do with actual losses. They're just there to scare you into paying on time and keep you in fear. There ought to be a statewide law on handling the temporary relocation of a tenant when the landlord really does need to have the tenant move out to perform major reconstruction. Mold infestation, collapsing ceilings, rotting floors, and fumigation are among the common reasons. Landlords may also plan to renovate the rooms with upgraded countertops and other features in order to jack up the rent even higher. Cities like Los Angeles have a special law and procedures that require the landlord to pay the tenant for hotel, meals, and incidental expenses as a condition of getting the permit to do the construction. But most cities have nothing. It becomes a battle where the landlord tries to bully or evict the tenant for not moving out upon his command for the tenant to eat the costs of hotel, meals, and other expenses for an indefinite period of time out of their own pocket. Your strength in that battle is under Civil Code Section 1954, discussed earlier here. Coming in to make extensive repairs, turning your home into a construction zone where you can't even be there is, to say the least, an abuse of the right of entry, and therefore you can prevent them from even coming in. Any part of the rental agreement that says you have to let them do that is itself illegal under Civil Code Section 1953. If the landlord tries to evict you for asserting that rights, you win, because it's a retaliatory eviction, and he has no right to do it. There's more information about this in the related video and on the caltenantlaw.com website. Having an attorney's advice about the particular circumstances in your case would be very helpful to make sure you're doing this right, to help draft up the agreement, and in protecting you against any eviction attempts. To legally break the lease, you have to have a legally recognized reason. You may have a job transfer, need to go back east, move in with a boyfriend or girlfriend, and other normal things. Those are not legal reasons to break the lease. If you have a monthly tenancy, you only need to give a 30-day notice, and that's it. You're not breaking the lease, just terminating it. But if you have a lease that won't end for a few months, that's where you need the legal reason. You might have a lease provision that says you have to pay 2 months' rent in order to get out of the lease. But that's probably not a legal provision because it's a liquidated damages provision like the late fee discussed earlier. There are ways around it. The easiest way to end the lease is under Civil Code 1942, mentioned earlier about repairs. If the landlord knows that you have a habitability defect and he has not fixed it, you can terminate the lease right now without further notice and legally terminate the lease as of the last day that you're there. It can be something minor, even one that you don't care about, just so long as it exists. You can download the habitability worksheet from caltenantlaw.com to help you identify what you can complain about to use as your legal reason for breaking the lease. You can also find a replacement tenant by advertising on Craigslist or one of those, download a rental application, and find a couple of tenants interested in renting, and send a copy of their applications to the landlord. You are not subleasing or assigning, so you don't need the landlord's permission. You're just leaving. You're doing this under Civil Code 1951.2, which says that if you leave before your lease is up, you owe the rent through the end of the lease minus what you can show the landlord could have avoided losing. So, the new tenant's eviction record, criminal record, credit score, or unstable employment are irrelevant. It's a good idea to do this as a backup to the 1942-based termination, just in case. This topic is discussed in greater detail in another video, which you should also review. As with the other actions you take, doing it correctly is very important, so a little legal advice on the particulars of your case would be a great idea. Hopefully, this video answered some of what you needed to know. There is a lot to the law, and it's hard to simplify for you in general terms because small circumstances could change everything. For now, it's important to know that your suspicions were correct, that you do have rights, and there is a way to accomplish what you want. Knowledge is power, and now you have it. Take charge.